Okay, please begin. Okay, and we are recording and live on Facebook. So thank you everyone for joining us. Chair Ochin, if you would like to, you may begin now.
Good morning, everyone, and welcome to today's virtual conference hosted by the County of Los Angeles Sheriff's Civilian Oversight Commission. This conference focuses on the topic of qualified immunity for law enforcement. Today, we will discuss the history of qualified immunity protections, the evolution of qualified immunity, its impact on the public, officer accountability, and the efforts made toward reformation of those obstacles regarding qualified immunity. Our hope is that at the end of this discussion, we will have outlined possible solutions to eliminate or reform qualified immunity broadly, but obviously we are particularly concerned about the effects of qualified immunity on folks who are impacted by police use of force in particular and other forms of misconduct. Today we have a diverse panel of speakers who will share their insights and expertise on this issue. We will hear first from Professor Joanna Schwartz of UCLA School of Law. Then we will hear from James Wheeler, the president of the Association for Los Angeles Sheriff's Deputies, otherwise known as ALADS. Then he will be followed by John Rafling, who is with the Human Rights Watch, and he is the senior researcher on criminal justice for the U.S. program, along with Timothy Talbot, who is an attorney in private practice with Raines, Lucius Stern, and Silver. We'll then open it up to questions from the moderator, and I'll be serving as moderator as well, and questions from attendees. Okay, so with that being said, we're going to go ahead and get started with the program. And so Professor Schwartz, I will invite you to start your presentation. Thank you so much for being here.
Wonderful, thank you. And thank you for having me participate in this important conversation about qualified immunity, which has dominated in many respects our current debate and dialogue about police accountability. And I think that the phrase qualified immunity has been thrown around a lot in our conversations. But hopefully this conversation that we're having here today can ground that discussion of what this doctrine is in the history of the doctrine and the impact that it's having today. And so that's where I would like to start, because I've done a lot of research over the past decade, understanding how qualified immunity works on the ground, and how its actual, the way in which it functions can inform debates about qualified immunity's future. So if you can turn to the next slide. It's important when thinking about qualified immunity to step back 150 years to the creation of a statute that's referred to now as Section 1983. But this is a statute that was created enacted by Congress in 1871 after the Civil War had ended, when across the South particularly, there was wide-ranging torture and terror of Black Americans. And Section 1983 was passed by Congress to create a right to sue government officials as well as these vigilantes for constitutional rights violations. And this statute, Section 1983, although it was enacted in 1871, it got very little traction with the courts for almost 100 years, for 90 years, the way in which the Supreme Court interpreted the law meant that it could really not be used for its intended purpose, which was to protect constitutional rights of the people. So next slide, please. Section 1983 was resuscitated by the Supreme Court in 1961 in a case called Monroe versus Pape, a case where an innocent Black man and his family were awoken from their beds in Chicago in the middle of the night by 13 police officers who pulled them out of bed and assaulted all the members of the family. And the case was brought under Section 1983. And for the first time, the Supreme Court said, this is exactly the kind of case, the kind of misconduct that should be remedied through Section 1983, through the ability to go to federal courts. That was 1961. And for 6 years only, where there was this the ability to bring these cases for constitutional violations unfettered by qualified immunity. But qualified immunity then came in to the scene in 1967. Next slide, please. The Supreme Court created without any, although they've talked about there being a common law basis for this defense, it was really, there's nothing in Section 1983's language that says that there should be a qualified immunity in these cases for government officials. But in 1967, the Supreme Court said there should be this qualified immunity for officers when they had acted in good faith. If officers thought in good faith that they were following the Constitution or following the law, and then it turns out they weren't, they should not be held liable. That was the beginning, the first time qualified immunity was described by the courts to apply to law enforcement and other government officials. But the court quickly expanded and repeatedly expanded what it meant to be protected by qualified immunity. Although it started as this good faith defense, in 1982, the Supreme Court said, we want it to be easier for officers to get qualified immunity, for them not to have to go through being questioned at trial, to not have it turn on officers' intent and whether they acted in good faith. So we're going to make it an objective standard so that it doesn't turn on what the officer was thinking, and instead grant officers qualified immunity unless they've violated what's called clearly established law. So then there became a question of what it meant to be clearly established law. 20 years later, the Supreme Court said, you don't have to have prior cases exactly, prior cases if it's an obvious constitutional violation. But for the vast majority of the Supreme Court's decisions over the next years, the Supreme Court has said there needs to be, unless it's this obvious constitutional violation, which the court has rarely found, there needs to be a prior court case so that it has, as the court said in White versus Poly, placed the statutory or constitutional question beyond debate. And that means that the law has to be particularized to the facts of the case. What the Supreme Court has indicated and what lower courts have understood is that in order to get past qualified immunity, the person whose rights have been violated needs to find a prior court decision with nearly identical facts in order for the law to be quote unquote clearly established. And the next slide, please. So when you hear about cases like this in the news, multiple cases repeat, and there are many, many more than the ones that I've described on this slide, where people whose constitutional rights have clearly been violated are nevertheless denied access to the court, denied remedy, because there happens to not be a prior court decision with nearly identical facts. And one example that I've included in this slide that it's worth just taking a moment to describe in a little more detail is a case by a man named Alexander Baxter, who had burgled a home, and then Nashville police came and looked for him. He was hiding in a basement. They found him, he raised his hands in surrender, and they nevertheless released their police dog on him, who attacked him under the arm because he had his hand raised for upwards of a minute, and he suffered significant harms. He brought a lawsuit. It was clearly established, it is clear law, that you cannot use force against a person who is surrendered. And in the very court that was hearing Alexander Baxter's case, there had been a prior court decision saying that it was unconstitutional to release a police dog on a person who had surrendered by lying down. But to the mind of that court, the factual distinctions between a person surrendering by lying down and a person surrendering with their hands in the air was significant enough to mean that it was not clearly established that what those officers did was wrong. And Alexander Baxter's case was thrown out of court and he was denied relief. Next slide, please. So why do we have qualified immunity? For the past 5 years, so that they have to, spend time in discovery and trial, and that it gives officers breathing room to make mistakes if they are reasonable mistakes. And in the slide that you see, I have given you some examples of the ways in which these arguments that have been made by the Supreme Court continue to be made, have been made in the past year or so as the debate about qualified immunity has taken center stage. The arguments, again, now being made by Tucker Carlson, by Republican Congressman Jim Banks, by the International Association of the Chiefs of Police, are just the same, that officers will be bankrupted without qualified immunity, that frivolous lawsuits will overwhelm the courts, and that officers will no longer be able to make split-second decisions. I have spent the past several years researching these justifications for qualified immunity, and I find that they do not hold empirical water. If you can, the next slide, please. I looked at 81 law enforcement agencies' payouts over a 6-year period, and I found that officers virtually never pay anything towards settlements and judgments entered against them. This is not because of qualified immunity. It is because states and localities have indemnification rules, state laws providing that local governments have to pay settlements and judgments on behalf of their officers in most instances. And those protections through the indemnification rules, not qualified immunity, is what shields officers from bankruptcy. Next slide, please. The idea that qualified immunity is necessary to protect officers when they make good faith mistakes is also unsupported by the evidence. And that is because the United States Supreme Court, when they have interpreted the Constitution and the Fourth Amendment, which really most often covers law enforcement officers, has said that reasonableness, that officers only violate the Constitution when they use unreasonable force. And unreasonableness or reasonableness is based on the notion, the recognition that officers have to make split-second decisions, and officers do not violate the Constitution when they make reasonable mistakes. As the court said recently, to be reasonable is not to be perfect, and the Fourth Amendment allows for mistakes on the part of government officials, giving them fair leeway for enforcing the law in the community's protection. That is the Constitution as interpreted by the Supreme Court, not qualified immunity, that protects officers who make split-second decisions in good faith. Next slide, please. Then there's the concern that qualified immunity, as ending it, would flood the courts with frivolous lawsuits. I don't have the time to go into all of these aspects in detail, but I will tell you that my research reveals that cases end far more often because of other barriers, not qualified immunity. I looked at almost 1,200 cases filed around the country, and for every case dismissed on qualified immunity grounds, 12 were dismissed for these other reasons. Not only the challenges of the constitutional standard, but other challenges related to requirements along the way, the ways in which judges can dismiss cases for multiple different reasons if they find them to be without merit. And because of that, there will be many other protections against insubstantial cases. Final slide, please. So if there are so many other protections to qualified, beyond qualified immunity, and officers don't pay settlements and judgments from their own pockets, what exactly would ending qualified immunity do? And why do I believe that ending qualified immunity is important? I have 5 reasons that I've identified in this slide. One is justice. People whose constitutional rights have been violated are currently being denied relief simply because they have the bad luck that there has not been a prior court case with virtually identical facts. And ending qualified immunity would offer justice to those people whose constitutional rights would be violated. Second, accountability. Courts are sending the message, in Justice Sotomayor's words, that police can shoot first and think later by insulating officers from any accountability, simply because they have the good luck that there has not been a prior court decision with virtually identical facts. And ending qualified immunity would stop sending that message in that particular way. There would also be increased clarity, because right now courts can grant qualified immunity without ruling on whether the Constitution has been violated. And so ending qualified immunity would mean that courts would better clarify the scope of constitutional protections. It would also simplify the litigation of these cases. Right now, qualified immunity dramatically increases the costs and complexity and time needed to litigate civil rights cases. And those costs would decline, which would mean more lawyers would likely be willing to take these cases, and we would get in the course of litigation to focus on what should be the critical issue in these cases, which is whether the Constitution was violated, not whether there was a prior case with virtually identical facts. And that is the final benefit, which is transparency, to be able to focus on these questions. This is a lot of information, and I look forward to the opportunity to elaborate on any of it that you have questions about, to answer your questions and to engage with my fellow panelists. Thank you.
Thank you very much, Professor Schwartz, for that wonderful overview and presentation of qualified immunity and the way that it often insulates law enforcement and other state agencies from accountability for constitutional violations, including, as you mentioned, excessive use of force, but not exclusively. But that's often, those are some of the issues that often raise issues related to qualified immunity. Next, we're going to hear from, we're going to put 2 folks in conversation, Mr. Wheeler and Mr. Talbot. As I mentioned earlier, Mr. Wheeler is the president of ALADS here in Los Angeles County, and Mr. Talbot is the principal attorney at Raines, Lucia, and Stern, a private firm, a law firm. And they're going to talk a bit about their perspectives on some of the issues that were raised by Professor Schwartz. So now I'd like to turn to you, Mr. Wheeler, to give us some of your thoughts on qualified immunity from a law enforcement perspective. Then we'll turn to Mr. Talbot to talk about it from the perspective of litigants. Mr. Wheeler.
Thank you, Madam Chair, and thank you, panelists. My name is Jim Wheeler. I've been deputy sheriff for 32 years. Currently the president of ALADS, which is our Association for Los Angeles Deputies. We represent approximately 8,000 deputy sheriffs. Although I am very familiar with qualified immunity, I definitely am a lay person when it comes to this, and that's why I brought Mr. Talbot. He is one of our panelist attorneys, and I will turn it over to him for his expertise on qualified immunity. Tim?
Thank you, Mr. Wheeler. So when I've participated in these discussions, oftentimes we're asked about law enforcement's perspective and this perception that law enforcement as a general matter is resistive to anything that's described or couched as a reform measure. I can tell you that that is not my experience on a broad level. I've been involved in the reform legislation discussions at both the federal and the state level and numerous discussions about qualified immunity. So I think it's helpful to start with just sort of the perspective, the non-legal perspective of law enforcement and why you hear some of the positions that they take. Now, I can't speak for every law enforcement association across the country. As many of you may know, there is not unanimity in the positions, even amongst law enforcement agencies across this country, on issues of police reform or accountability and some of these other terms. But I can offer a perspective based on my personal experience in representing law enforcement officers for almost 27 years. So one of the things, and I appreciate Professor Schwartz's last slide about what some of the objectives and goals of eliminating qualified immunity might be in the eyes of some individuals. But I think law enforcement wants to hit the pause button because this discussion currently about qualified immunity doesn't arise in a vacuum. While the academics have certainly been discussing this since the early 80s and commented on the transformation that was described over the years that the Supreme Court has taken in this doctrine, many of us sit back and say, we are under attack as law enforcement officers. We are being approached from many different angles and directives where what they have known to be the case is now suddenly being questioned. Rights that they've had, protections that they've had are now regarded as suspect. And frankly, there's just a call to eliminate those things under this guise of accountability and transparency. So the real question is, what is the objective in eliminating QI? Well, certainly that statute exists to provide compensation for injuries resulting from the deprivation of constitutional rights. It is inherently, it is a civil statute to provide monetary relief. So what we are faced with are individuals who are seeking compensation, first and foremost. And so the question is does the elimination of qualified immunity actually accomplish some of these bigger goals that have been articulated, such as changing police procedures, police policies, some of the things that the public has identified as concerning to them or in need of reform or attention. And I think the concern of law enforcement is that eliminating qualified immunity may not have the impact that others espouse or believe it will, that the kinds of change and reform that people are seeking must be multifaceted, and that in most circumstances, what you're really looking at are expansions or changes in the rules and the understanding of the law as it's applied, which is what the outcome of civil litigation or what folks are saying is not resulting from the application of qualified immunity. The ability to add those new standards, those new procedures exists every day within agencies. And in fact, the state of California enacted a law, SB 230, specifically mandating that agencies adopt certain policies and procedures to improve the manner in which law enforcement operates and those services are provided. But we get tripped up on our side from a lot of things that we hear. Part of this entire presentation assumes the need to eliminate qualified immunity and that it closes the courthouse doors to many litigants. And as Professor Schwartz knows from her own study, that's simply not the case. I believe her research indicated that just less than 4% of all the civil cases that were filed were actually dismissed as a result of the assertion of a qualified immunity defense. That's a very small number, and she confirmed that today, that many, if not most of the cases are dismissed on other grounds. So the assertion that qualified immunity is blocking the courthouse steps or is single-handedly responsible for injustice, I think is an overstatement. And Professor Schwartz's paper, I think, corroborates that as the case. So the entire discussion begins from a fundamental misunderstanding of the impact of qualified immunity and how it operates. And I think, that causes law enforcement to pause, particularly when we hear statements like, use of force and other misconduct, which was in fact uttered on this call. The use of force by law enforcement officers is not per se misconduct. They are legally entitled to use force in the performance of their duties for legitimate and lawful reasons. But the public doesn't like the use of force. It's ugly, it's graphic, and so they associate all uses of force as misconduct and that bad cops are doing this. And so they're seeking all sorts of changes that, maybe those discussions should be had, but a lot of times they are misguided, frankly, in terms of how you achieve the overarching objectives. Now, from the law enforcement perspective and the cop on the street perspective, this is really an employment matter. And I don't think a lot of people think about it in that way. But cops are employees and they come to work, and just like any other employee, they're told, these are the rules you must follow. You can always do this. You can never do that. And as long as you're following the rules and doing your job, you're okay. The challenge is that unlike some jobs that have very simple tasks, don't require a lot of discretion and the ability to apply fairly generic rules to a specific set of facts under extremely tense and quickly developing circumstances, law enforcement officers are required to use their judgment. We don't have in the Constitution a long list of exactly what is and isn't permissible for Fourth Amendment analysis. We have a reasonableness standard. And so as an employee, the employer says, okay, go out there and make sure everything you do is reasonable. Take into consideration what the courts have said about the law, what our policies are, and what your training is, and do the best you can. And so they do. And when they do, somebody may get injured, may have a claim, and then the individual gets sued. And under the 1983 statute, that's the only mechanism available, is to sue the individual because of the history, because of the development as a Reconstruction statute and the way it was enacted. It doesn't allow for suing the agency for the acts of the individual. But in every other employment context, the employer is responsible for the actions of the employee when that individual is acting within the course and scope of their employment. And typically, you would not sue the individual, you would sue the employer. But under the 1983 construct, that's not possible. And so, yes, no employee wants to be sued. And it's not enough to say someone else is paying for the damages. You still have a judgment against you as an individual. You still may have a finding, and you may have to go to trial. And while the Supreme Court articulated a lot of reasons, which I know many of the scholars are less than satisfied with in terms of the rationale for qualified immunity, what they're saying is just like any other employee would want, which is, if I'm there doing my job the best I can within the parameters that were described to me, why should I get sued for it? And so we look to that standard of clearly established so that there is a rule that can be followed and universally applied. It's a rule, and the rules in terms of what the Fourth Amendment means are developed by the courts. And so you have to look to those court decisions in order to know what the rules are. And whether we like it or not, it's the US Supreme Court that has the final word on it. And so when we get to cases where they change a word from a reasonable to every reasonable, it's their attempt to say, we don't want law enforcement officers to be confused by the holding in one court in one jurisdiction compared to the other. We want the final word. Now, I would acknowledge that process of defining the law is slow and probably doesn't meet the current need for that consistency and development. But there are ways short of completely eliminating qualified immunity that can accomplish that. I don't think any employee, and certainly not cops, want to go all the way back to your intent doesn't matter, although the Supreme Court sought to do that by making it objective. But if we throw it out, good faith is eliminated, going all the way back to Pearson. There's no defense. And that will, whether we like it or not, cause employees, cause cops to say, if no one's going to support me and I'm going to be blamed, then why should I do this job? And one final comment on that. While it is true that the individual cops are not currently paying for most of those judgments, and the employers are by virtue of state law, those state laws can be changed. And what has happened in the past in terms of the defense and indemnification is no guarantee in the future. And in fact, there have been recent calls around the country to eliminate those types of defense and indemnification provisions. So the concerns for these officers trying to do the job are real, and relying solely upon a promise by state legislators that they will defend them and pick up the cost, I don't think they can rely on that. And for those reasons, the debate should be more focused on how to reform potentially rather than eliminate.
Thank you very much, Mr. Talbot. We're now going to transition to John Rafling of Human Rights Watch, and then we will I'll pose some questions to the panelists, and I'm going to hand it off to my colleague, the Executive Director of the Commission, Brian Williams, to moderate the public comment, because I have to step off for a bit. But now let me turn it over to you, Mr. Rafling, to talk about your perspective on qualified immunity.
Great, thanks very much, Professor Ocean, and appreciate being asked to speak today. So I'm John Rafling. I work for Human Rights Watch. I conduct research, I write reports, and I do advocacy around policing and around court reform within the U.S. criminal legal system. I've been doing that for about 5 years now, almost 5. But for 20-some years before that, I was a practicing attorney, and I litigated cases related to policing, primarily as a criminal defense lawyer, but also bringing lawsuits in both federal and state courts on behalf of victims of police misconduct. So I have some experience with the issues that are brought up in today's panel, and throughout my career, I've worked very closely with individuals and with communities that have felt the harmful impacts of abusive policing. So qualified immunity, simply put, is a legal doctrine that allows police officers, and more importantly, and by extension, police departments, to escape liability when they break the law and cause harm to people. Now, Professor Schwartz gave a very good explanation about how the law is quite flexible as to police officers, meeting Mr. Talbot's concern about officers not knowing what they should be able to do and having to exercise discretion. Right? She explained that there's this reasonableness standard that's extremely flexible, and in fact, the wording in the jury instruction about it is that we're not to view from the perspective of 20/20 hindsight. In other words, we're giving officers a great deal of leeway in terms of making judgments and discretion within the moment. But qualified immunity is something quite different. Qualified immunity says that even though we have determined, or even if we determine that the action violates the law, violates a person's constitutional rights, there's still no liability. There's immunity, which means you can't even follow through with the lawsuit, right? That's what immunity means. Because there hasn't been some prior case that where a violation was made in the exact same way, or almost exact same way. It puts officers above the law. We need to abolish qualified immunity. But we should understand, and I think both Professor Schwartz and Mr. Talbot made this point in different ways, that abolishing qualified immunity is a very small piece, an important but a very small piece of the police reform puzzle that we have to complete here. It's a crucial but minimal step towards reforming policing. Let me give an illustrative example of a case of qualified immunity that happened, a Ninth Circuit case, so the circuit that covers California, Jessup versus City of Fresno. And I'm not going to go into deep detail, but basically the allegation in the case was that police officers in executing a search warrant stole $275 worth of cash and did I say $275,000 worth of cash and rare coins. So the allegation was theft, right? Straight up theft, right? We talk about excessive force and other misconduct. This is one of other misconduct. This is not a split-second decision. This is an allegation of something very deliberate and clear. Now, we're not saying that there's proof that they did it. That's for trial. But there's an allegation that they did it, and that's what the court was evaluating. And the court, and this is a panel from the Ninth Circuit, said, well, we agree that theft is obviously morally wrong, right? You're not supposed to do it. And we also understand that the Fourth Amendment, right? These are generally around Fourth Amendment cases, says that you're to be protected from unreasonable searches and seizures. And I can't imagine anyone arguing that stealing $275,000 worth of property is a reasonable seizure. But the court said, well, we've never addressed whether theft of property covered by the terms of a search warrant violates the Fourth Amendment. Case dismissed. The thieving officers have immunity from prosecution. And here's the other thing, and this is an evolution in the law that is important to understand. Initially, the way the qualified immunity analysis went is the court would first make a determination whether this was a violation of a constitutional right. Okay, and then they would decide, well, was it clearly established? And that's important because at least then the next time a police officer stole something while executing a warrant, it would at least be a clearly established right. And so we'd have some evolution in the law. Well, some years back, a case, the Pearson case, I believe, said, no, the court doesn't even have to make that initial determination of whether it's a constitutional violation. They can just say whether or not it's clearly established. And so the Jessup court didn't say stealing was a constitutional violation, though morally wrong and clearly unreasonable. They just said, it hasn't been clearly established. And so the next time a police officer steals in the course of executing a warrant, there's still no clearly established law saying that that's a violation. So here's then the question, how do we decide whether something is a violation has been clearly established, right? And as Professor Schwartz described, well, is there some prior case that is sufficiently similar to the violation that the person is claiming in the current case? Well, what's sufficiently similar, right? There's there's some standards about it has to be beyond debate. What does that mean? And here's a crucial thing. It depends on the judge, right? There are some judges who are very supportive of civil rights claims who may be more flexible. But then you get other judges who are hostile to civil rights claims or extremely deferential to police and to law enforcement. That's most of them to some degree or another. Or you get judges who are just plain biased. And they can use qualified immunity to destroy just about any case, right? Qualified immunity is a powerful weapon to protect police from accountability and to deny people any remedy for violations of their rights. And a right without a remedy is just useless words. A right without a remedy is a recipe for impunity, and a lack of consequences encourages law enforcement by police. We need to get rid of qualified immunity entirely. Important to understand a larger context of qualified immunity. One, as Mr. Talbot related. It's about compensation, right? A victim of police misconduct, be it excessive force, theft, some other thing, should be able to get paid back, to be compensated, to have some repair for that damage, and qualified immunity frustrates that issue. Now, Mr. Talbot makes a really important point, which is that under federal civil rights law, the department is not liable, it's the individual. And that's a big problem. If I work for a regular employer that's not law enforcement and I commit a harm in the course of my job, my employer is liable. That's not the case with police, at least under the federal system where most all of these cases are brought. And so that might be a reform that we should do, so that it isn't on individual police officers, but the police departments, who pay anyway, are the ones found liable. But the other part of the big picture is how qualified immunity undermines accountability, right? Officers are rarely prosecuted criminally. Departments investigate themselves, and truthfully, in my research and what I've seen, they rarely impose meaningful discipline. So civil lawsuits become the default. And if officers don't suffer consequences, and more importantly, the departments don't have consequences for misconduct and rights violations, then that again leads to impunity and lack of accountability.
Thank you very much, Mr. Reifling. I appreciate your presentation and really helping us understand how the doctrine has evolved, in addition to the comments of Mr. Talbot and Professor Schwartz. I think it's really important, the point that you underscored, that courts now don't even have to address whether there has been a constitutional violation in the first instance. They can simply jump over to whether it's a clearly established right, and therefore that essentially becomes a repeating process, right? So for every case, they can simply say it's not clearly established and not describe what the Constitution requires in a particular set of circumstances. So I want to ask a couple of questions, and then I'm going to open it up to the public for their questions. So for those of you who are attending who want to ask questions, what you can either to a specific panelist or to the entire panel, you can click the hand symbol at the bottom of the participant window, or send a chat to the host to get in the queue. All right, so get your questions ready, and we will be posing to them after I ask a couple of questions here. So I want to start with where Mr. Reifling left off, and so I'll pose it to both Mr. Reifling and also to Professor Schwartz. One of the things that Mr. Talbot said was that, Section 1983, this, Civil War Reconstruction era statute designed to protect Black folks in this country against racial terror under the color of law, including law enforcement, but not exclusively, is primarily about compensation. And I'm wondering if you all can respond to that. Is Section 1983 primarily about compensation, or are there other objectives and values that are at stake?
I would be very happy to jump in. I think that since from the very beginning, the goals of Section 1983 have been two: compensation and deterrence. And Supreme Court cases that have talked about what Section 1983 is intended to do have said both of those things are key goals: compensation for people whose rights have been violated, and deterrence, meaning that the goal has been not simply to pay people whose rights have been violated, but also to prevent future similar harms. And if you look at the Supreme Court's decisions about this, you will see the idea that individual officers who have been sued should be deterred, that police chiefs and officials should take note of what happened in these prior cases and make efforts to change policies or personnel to prevent these things from happening in the future. Now, there's all sorts of reasons why both aspects, I think, of the promise and potential of Section 1983, the goals of Section 1983 are being undermined. I think that people are not being compensated when their rights have been violated because of qualified immunity and a host of other reasons. And I think that local departments, police departments, and local jurisdictions, I think, don't learn enough, don't make enough effort to learn from the lawsuits that have been brought against them. And just one brief sort of point of information here. Police departments cannot be sued, but local governments can under Section 1983. The Supreme Court has said it's not just individuals that can be sued. It is local governments as well. But this is a conversation for another time. But the Supreme Court, as the Supreme Court created qualified immunity, which makes it very difficult to sue individual officers, they created a whole other set of legal rules that makes it very hard to sue local governments as well. That's a topic for another day, I'm afraid, although it's certainly related, very related to this conversation, because both of those limitations put together make it very difficult for people to get the compensation and deterrence that they are supposed to get from Section 1983.
Thank you, Professor. Mr. Raufling or Mr. Talbot, do you want to respond, or should I move on to the next question?
If you may, I'd like to just respond to a couple of comments on this compensation piece, and it goes, I think, primarily to the discussion about Jessup. What's missing from this discussion is that 1983 is a particular cause of action. There are state law causes of action for negligence and torts and other ways where individuals can seek redress for what they perceive to be misconduct by law enforcement officers. The reason why we don't hear much about those is because they don't provide the attorney fees and the kinds of economic penalties that Section 1983 allows for. So they aren't the go-to for the lawyers that are bringing those actions. But in Jessup in particular, I think it's noteworthy that, yes, while there was a search warrant executed for the seizure of that property, the pleading and the court found that there was a subsequent theft, a discrete act, and that there were only 2 cases that the court could find across the country that even addressed this issue. And the reason they went to the immunity piece first is that it was pled as a theft, it was pursued as a theft, and it was a discrete act that did not implicate, based on existing law, the Fourth Amendment. So I think there's some nuances in these things that do matter in terms of the discussion about the application of qualified immunity.
Thank you. I want to ask a couple of questions about qualified immunity and these civil cases alleging violation of constitutional rights. And this question I want to pose to Mr. Raufling and Professor Schwartz, if you want to chime in here about, we've heard sort of the perspective of, employee unions for law enforcement from Mr. Talbot, but I want to hear from you all your perspectives on the potential chilling effect of qualified immunity for folks who are victims of police misconduct and their ability, for example, to get an attorney. I was a civil rights attorney in the Bay Area, and when we had folks come to see us about particular issues, if we researched the case law and didn't see something that was clearly established, it might cause some hesitancy in terms of taking on the case, given that we might know the ultimate outcome. And I'm wondering if that's something that you see in your work, either Mr. Raufling or Professor Schwartz. I'm wondering if you could comment on the chilling effect for folks who, we're talking about people who get into court, but what about people who want to get into court? Can they get attorneys? Will attorneys take on those cases?
Right. Well, I think that's a really crucial point. While a certain number of cases get dismissed based on qualified immunity when after they've been filed, we don't have a metric of how many cases don't get filed at all because a lawyer calculates, if I take this case, I'm going to sink so much time and so much money that it's just not feasible to do it because there's a high likelihood that it will get dismissed based on qualified immunity or one of dozens of other ways that courts that are hostile to civil rights claims would find to dismiss or otherwise defeat cases. So it does have a potentially very strong deterrent effect on filing of cases, even cases that are good cases. And it particularly impacts the smaller cases, right? So, you know, the wrongful death cases might get filed because there's a potential for a big verdict or a big settlement. Whereas a smaller case, a wrongful arrest, where there's truly a violation of rights, attorneys are going to be dissuaded from taking those kind of cases. I know this very much from experience. I took some of those smaller cases and ended up losing money on them, getting them dismissed and defeated in court for a variety of reasons, among them qualified immunity. It's one part of this whole reform puzzle in terms of accountability and compensation.
If I may jump in just briefly, I actually have interviewed. I was a civil rights lawyer as well, but so I have my own personal experiences. But I've interviewed more than 36 plaintiffs' lawyers who have brought civil rights cases in this larger study that I did, and they confirm what John is talking about. Understand that lawyers who bring these cases, there's a lot of people have a lot of scorn for plaintiffs' lawyers and make a lot of disparaging comments about plaintiffs' lawyers just trying to make a buck off somebody else's misery. Understand that lawyers who take these cases are not being paid by their clients. They are investing their own time and their own money bringing these cases and only get paid if their client prevails, if their client gets a settlement or a judgment, and then gets a percentage of that award. And what qualified immunity does is dramatically increase, and this is, you know, consistent with common sense and with what lawyers have told me, dramatically increases the time and complexity it takes to bring these cases. You have to find a prior court decision, not just that establishes the principle that you can't, for example, use force against someone who's not resisting, but go through cases to try to find one that has the precise factual circumstances that you are describing. And then if an officer brings a qualified immunity motion and it's denied, meaning the case is supposed to go forward, though that officer can immediately appeal that denial, and that appeal can add an extra year to the case. And that extra year, in addition to, you know, delaying resolution of the case, is more time, more money, writing a different brief, arguing in a different kind of court. And all of those things add cost and complexity to these cases. And what I found is consistent with what John said, that lawyers are less inclined to bring lower damages cases. These are cases that can have very severe injuries, or you know, where people have been arrested, where people have been wrongfully arrested, where they've been held, where their dog has been shot, where, you know, where serious harms have happened that simply aren't going to translate into significant injuries. But the more significant thing that I found was that the challenges of qualified immunity discourage lawyers from bringing civil rights cases at all. Lawyers who bring civil rights cases, many of them, are not you know, dedicated 100% of their career and their life's work to civil rights work. Many are lawyers who are balancing personal injury work or criminal defense work or medical malpractice work with civil rights cases, and are you know, need those other cases to keep the lights on, because civil rights cases are so unreliable in terms of money making. And many lawyers will bring have a person come to their office with a story so compelling they can't turn it down. They take the case, they invest tens of thousands of dollars of their own money, and then the case gets dismissed on qualified immunity. And they think, you know what, I could either invest hours and hours of my time to try to understand this doctrine, invest all of the time to try to brief these cases and get up to the Court of Appeals and understand how to litigate before the Court of Appeals, even though I never did it in any other case. Or I could go back and litigate the personal injury cases and the medical malpractice cases and the contracts cases that are far more reliable and keep the lights on. And you know what? I'm going to do that instead. And so qualified immunity not only means that individual lawyers aren't going to bring low damages cases, it means that we are reducing the number of lawyers willing to bring any of these cases at all. And so it is true that, as Mr. Talbot said, I did find that only about 4% of the cases that I had studied were entirely dismissed on qualified immunity. A larger percentage of cases had qualified immunity grants. But the number of cases, and I should say, those are the cases, because it's only 4%, we should all be agreeing we could eliminate qualified immunity, and it would result in a relatively insignificant number of additional cases that get relief. But those are the worst cases, the cases where there's been constitutional violations, where people have had their constitutional rights violated, and the only reason that they're kicked out of court is because there doesn't happen to be a prior court decision. But then there's a much broader ripple effect on lawyers' willingness to take civil rights cases at all because of the immense burdens that it imposes in litigating these cases and getting to a jury.
So I want to thank you very much for those responses, everyone. I want to pose this question starting with Mr. Talbot. One of the things that you've said and others have said from the perspective of law enforcement is that if qualified immunity is severely curtailed or abolished outright, that it will be a disincentive for folks to join police forces or to become law enforcement officials, that it might cause police officers or sheriff's deputies to think twice before they use discretion that might then end up in civil litigation without the protection of qualified immunity. And one of the things that you said during your remarks, Mr. Talbot, is that police officers or sheriff's deputies, they occupy a particular kind of space in society in terms of what we're asking them to do. We're asking them to make split-second decisions, to use their discretion in, rapidly evolving, changing dynamics, sometimes dangerous situations. Here's my question for you. So there are other professions that are asked to do similar things, right? We can think about firefighters, EMTs, doctors, private prison guards, officials and other officials in private security. They don't enjoy qualified immunity, right? And it doesn't seem to be an issue. So I'm just wondering if you can comment about that disjuncture. The fact that we do have folks that are in similar kinds of fields that don't enjoy qualified immunity, and it doesn't seem to have a chilling effect on them joining the profession or using, their discretion in different situations. I'm wondering here, so here's the question. Why would it be different for police?
So let me just address this question of the application of qualified immunity. So it does apply to any government official who exercises discretion. There are examples of paramedics and social workers and other folks that make decisions where they have been sued for violations under 1983, and qualified immunity would be available to them. So I have to take issue with the fact that those folks don't enjoy that. I've had cases where paramedics in particular, were accused of basically by force keeping somebody in the back of an ambulance as a 1983 violation. So it does apply to them. But I think the bigger distinction that, and I've heard this before, is, well, what about, doctors and other people that are asked to do high level things? I think an important distinction between law enforcement officers and most physicians is that physicians, the patients come to them. They get to pick and choose what cases they want to handle. ER docs might be a slight exception to that, but it's an incredibly controlled environment in which the patient enters into their sphere and they're asked to do things. The exact opposite applies to cops. They are told right now, run into this situation and go at it without the benefit of people coming to you controlling the environment and things like that. So I do think that distinction is important to recognize as to why some of these protections in terms of trying to do the right thing to the extent the Supreme Court says QI protects those good faith mistakes or people make mistakes. And I firmly believe that there's a difference between mistake and misconduct. And that distinction gets lost in this debate too often because, again, of what I've said of people's view of it. But and then, I don't really want to go down this other type of protection because they're employees compared to like doctors who are professionals. They do a different type of service, but a cop is an employee. And I think everybody on this panel to some extent has acknowledged that really the employer should be responsible. And as it plays out, because of state laws, the employer ends up being responsible. But employees don't want to be told they are going to be liable for trying to do their job correctly. And I think even if mistakenly so. And I think that's the biggest difference between them.
Do you
Hope that
think
answers your
difference?
question.
It does, and I appreciate the clarification. Do you think that difference applies? Because my understanding is that, for example, people who are guards in private prisons don't enjoy qualified immunity. Does that in any way change your response? So you have folks who are in those spaces who don't have qualified immunity, who are operating in, very similar kinds of spaces as police officers. And, it doesn't seem to, I haven't seen a lot of stories about private prisons not being able to recruit staff. Well, I won't push that too far, but I'm just wondering, about that basic point that employers are still able to get employees to step into these roles, even absent qualified immunity.
Well, I mean, I think the private correctional or custodial officer characterization is the difference because those employers are going to be responsible for the conduct of those employees. So setting aside all the reasons why somebody may or may not want to be a correctional officer, if they're walking into that environment, somebody can and would have to show them that, look, we are on the hook as the private employer for what goes on within the facilities for which we have contracted our services and your actions as an employee. And that is the critical distinction.
I'll just say this. It seems that there's a lot of similarities, though, because as you said, and I'm going to move on, cities, states, they cover liability for their employees. So it just seems like doubling down, right? Because one, you both get qualified immunity and you're insulated from covering the cost if there is a finding of liability, right? So it seems to me like there's a similarity between the private prison situation and law enforcement. But here's the question that I have for all of you. We have these civil cases that may make it to the trial stage or past summary judgment alleging qualified immunity. So my question is, do cases where there is actually a determination about a constitutional violation, is that limited just to constitutional civil cases, or does that actually shape how criminal cases might be litigated if there is not only a allegation of civil misconduct, but also criminal misconduct? Our cases say that the Supreme Court decides about use of force in a Section 1983 context. Are those used in criminal cases at all? And so my question essentially comes back to, what is the consequence of a court not making a constitutional determination? Is it simply limited to the civil sphere, or does it also impact potential criminal liability?
I can take a shot at answering that because I think it is a good point, right? The Supreme Court establishes the law, constitutional law, and often we're talking about Fourth Amendment law here, sometimes Fifth Amendment or even Sixth Amendment law. And so as particularly, let's say a violation of the right against an unreasonable search, well, that comes up in a criminal context all the time. It may also come up in a civil case, in a 1983 case. And if the courts are just simply not making decisions and not defining what the law is in at least one part of one sphere of cases that are coming to them because they're jumping straight to the clearly established prong of the qualified immunity analysis, then we're not developing the law as it applies to criminal cases as quickly, as efficiently, and as clearly. So it can have, it definitely can have an impact. And that's also particularly important right now as technology has more and more of an impact, as cell phone surveillance, facial recognition technology becomes more and more implemented. The rights and the parameters of what police can do and what our rights are as citizens are more and more up in the air. And the less the court, and the more the courts can dodge making decisions that clarify what our rights are and what the limits are on police, that will cause problems and lack of clarity and harm through violations of rights.
Thank you. So I want to just sort of now shift our conversation to what, we talked about the problems with qualified immunity, potentially some of the benefits from the perspective of law enforcement. And one of the things that we really want to talk about with you all is, what can be done, what should be done to reform or eliminate qualified immunity for the ultimate purposes of ensuring accountability for law enforcement. I think all of us would agree that people who engage in misconduct should be held accountable, right? So if that is the case and qualified immunity is an impediment, so let's just posit that that's true to some degree or another, whether you reform it or abolish it outright. What have other jurisdictions done? I'm familiar with, I think Colorado moved to eliminate qualified immunity. What has the impact been? What can oversight bodies like the Civilian Oversight Commission here in LA County do to be a part of those conversations and policy movements? So those are my questions. What's the landscape around qualified immunity, particularly after the murder of George Floyd? And then two, how can folks in LA County, bodies like the Civilian Oversight Commission, be a part of this national conversation? So I'll open it up to whomever would like to start us off. We started with Professor Schwartz, and it looks like you're gesturing like you want to jump in, so I'm going to turn.
Yeah, I would be happy to jump in. And I've been involved in many conversations, both at the federal level and state and local levels as well, thinking about qualified immunity reform. Colorado, as you mentioned, was the sort of first actor in this space. In the month after George Floyd was killed, there was a state statute enacted with bipartisan support, and the statute provided that there was a state cause of action, meaning you could sue under state law, like Section 1983. That's a federal law. The Colorado statute said under state law, you can sue law enforcement for constitutional violations of the Colorado state constitution, which is similar to the United States Constitution, and that qualified immunity was not a defense to the claim. But they did something else, and I think it's something that Mr. Talbot will like. They said that local governments must indemnify their officers in these cases so that the money would be paid by the local governments. But there was one carve out, which is that if the local government found that the officer had acted in bad faith, that officer could be required to pay up to $25,000 or 5% of the settlement or judgment, whichever was lower, unless the officer could show financial hardship that they couldn't pay that amount, in which case the local government would pay everything. Now, here is what I think that statute accomplishes. It provides, if we're thinking about compensation and deterrence, it ensures compensation for people whose constitutional rights have been violated, and ensures that they will be paid largely or exclusively from the government as opposed to the individual officer. But it provides, if the officer is found to have acted in bad faith or wrongfully, they can have a financial sanction. It is a sanction that will not bankrupt them, and specifically couched in the statute that the intention is not to bankrupt the officer, but to create a financial penalty for that officer. And it does one other thing in in the background, which I think is valuable, which is that it requires the local government to at least take a look at the lawsuit and take a look at what happened in the case and assess the officer's misconduct. I've found in other research that many local governments don't do that with lawsuits, don't learn from the lawsuits that have been brought against them. So I think the Colorado statute does advance goals of compensation and deterrence in a interesting way. Other states have considered legislation. New Mexico passed a statute. There have countless commissions in Kansas and Illinois and Massachusetts, and California has considered similar changes that have as yet not been successful. But none of them include this portion of the Colorado statute that I find promising, that does create this financial sanction for officers who've been found to act in bad faith. There is also, for the purposes of your question about what Los Angeles can do, New York City Council created their own cause of action. So it doesn't only have to happen at the federal level. It can happen at the state level. It doesn't have to happen at the state level. It can happen at the local level as well, to create a local cause of action for violation of the Constitution. But I think that there's more even that local entities like this one and local government bodies can think about doing to increase the deterrent effect of these suits. One is to encourage local governments to learn from the lawsuits that have been brought against them. As I had mentioned before, many local governments don't take the time to gather and analyze information from lawsuits brought against them, and often that key information is kept in lawyers' files without going into the files and the assessment of local governments. I don't see why local governments cannot require collection and assessment of information from those lawsuits as a condition of the budgeting process or the indemnification agreements. Los Angeles County does this to some extent with corrective action plans, but when they agree to settle a case, they sort of say what they can learn from that case. But there's lots of lessons to be learned from lawsuits evaluated across cases, to look at trends in cases. Why are these cases continually being filed? And what can we learn from these cases? Los Angeles County did that in the past with a special counsel named Merrick Bob, who did that kind of analysis. He's no longer doing that work, but I think that it can be reinvigorated. And I think that there's one other point, which is that local governments, and this is, I think, gonna concern Mr. Talbot when I say this. I recognize that this may cause some concern for him, but qualified immunity is an affirmative defense that's being raised by attorneys that are being provided for officers as a condition of the indemnification agreements, and those lawyers are providing counsel for the officers, but recognize also that in a situation in which an officer is promised indemnification, and under California law, officers have to be indemnified if they acted in the course and scope of their employment, except for punitive damages. But there's a decision being made to pursue qualified immunity appeals and interlocutory appeals, immediate appeals of these denials, even when there's proof of constitutional violations. And I think that we, as in local government, or local government commissions like this, can be thinking about how we are using our resources, how we are spending our time pushing these qualified immunity motions and appeals for cases of clear constitutional violations, and maybe reconsider that expenditure of time and resources moving forward.
Yeah, and so it sounds to me, just in terms of the local government piece, which is obviously where we have the most influence, we can be thinking about the importance of constitutional officers embedded in and having significant influence in agencies like the Sheriff's Department or LAPD that can assess lawsuits and implement learnings from them in ways that are rigorous and actually have an impact in the disciplinary process and in the training process. The other thing that I think you're describing is maybe something akin to a waiver of an affirmative defense of qualified immunity as a matter of policy from the LAPD, the Los Angeles Sheriff's Department as a county or city matter. So I think those are things that we can follow up on and pursue that can help us address this issue of qualified immunity without waiting on the federal government or waiting on the state legislature to take action. At this point, I am going to turn over the conversation to my colleague, the Executive Director of the Los Angeles Sheriff Civilian Oversight Commission, Brian Williams, to take comments from and questions from the public. I'm going to mute myself, but I'll be back just before the end of our conversation. Mr. Williams.
Thank you, Professor Ocean. In the spirit of the Olympics, this is pretty much tag team moderating. So she's handed the baton over to me. Before we get to the public, I did want to ask just a couple of more questions. One, and I guess these are for perhaps Professor Schwartz and Mr. Talbot and Mr. Raffling, and you too can answer if you want, Mr. Wheeler. But looking from the opposite side, let's start with you, Mr. Talbot. Can you think of any reason that we should amend or somehow do something with qualified immunity? In other words, what are the negative aspects that you see of qualified immunity from the community's perspective? And Professor Schwartz, I'd ask you the same question, only in opposite. What are some of the positive things you see in terms of qualified immunity? Either of you can start.
Thank you for that question. I think we've touched on a couple of those things. And I know Professor Schwartz has dressed down a number of the reasons or the rationale by the Supreme Court and others. Look, we have what the court has said, and I think, this idea of dispensing with frivolous lawsuits and getting defendants out of cases early, I don't think the evidence supports that actually happens. I think she did a pretty good job of debunking that. But what it does do is it prevents cases from going to trial. And anybody that's litigated a case knows discovery is one thing, dispositive motions at summary judgment, certainly tedious, but a trial is a completely different undertaking, and it's quite monumental. What we seldom have the benefit of on these panels is actually the attorneys representing the public entities. I find for whatever reason they're unwilling or they're just never invited, but they are critical for all the reasons that we've identified, that they are in the driver's seat, if you will, in the defense of these cops. And so when you think about it, what they are deciding is if the cop is out of the case for any reason, then we are off the hook as an entity for liability on that particular cause of action. So in one way, because it's hard to reconcile all the data, on one way you could say the public agency is saving taxpayer money by not paying out potentially on one of these claims. Now, obviously the converse of that is that there's maybe an uncompensated injury out there, which is the balance that has to occur. But I think you could say it doesn't necessarily mean that we're going to pay out. Yes, there's resources, there may be government attorneys. It may not, that work may not translate into a bigger price tag for the government. That's one.
Let me ask you, I just want to follow up with, and we'll get to you, Professor, but that sort of takes out of the equation the human factor. If there's a plaintiff who has believed they've been wronged by a police officer, they want some compensation for their families. So where then does that come into play in terms of your analysis?
Well, so it's not entirely my analysis, right? I'm taking it from what the courts have said. And you're right, that's the push and pull between compensating injuries resulting from violations of civil rights. And we've heard that you know, this is definitely a point worth considering. If the constitutional question is decided first, it certainly has some advantages to defining the law and helping to prevent potentially repeats of the same kind of stuff. And there is a little known case out there, the name escapes me right now, where the Supreme Court actually said it would review cases that were decided on the qualified immunity piece without deciding the constitutional question. They'll actually take those for review, but they're the only entity that will. So I do think that you know, there's some tweaks, if you will, that can help do it. But that's one thing. The second thing is, while everybody just is dismissive of this idea that people won't be law enforcement officers, they're doing it from the benefit of hindsight. Why were we having trouble recruiting officers 3 and 4 and 5 years as compared to what we see now? In my practice, I've seen pretty significant exodus of officers who might have remained employed but chose to retire at the first possible time, others who have left the profession altogether, and certainly more people who don't want to enter the profession. Do I believe that that is 100% because of qualified immunity? No. I mean, the reality is that probably the majority of cops weren't even aware of qualified immunity until it was raised after George Floyd. Okay, they are now. They now understand what that means. They now understand the implications. I don't think that allies their concerns. I think it exacerbates their fears and that their employers will leave them hanging. But, you know, the Colorado model that Professor Schwartz described, you know, it does address the primary concern. And I've certainly heard others articulate ways to get to that, which is compensation for the injuries. Those people who are identified as victims of civil rights violations, compensating them and finding a means to do that. You know, certainly 1983 and the way it's developed isn't the best, probably the best mechanism to do that for all the reasons that we've talked about. But there may be other options short of, and it's significant because of that bad faith reference in Colorado. It's significant that what's on the table right now is throwing the entire subjective piece of this out, the baby out with the bathwater, as they say. And certainly the attempts in California to amend the Bain Act and those things that have failed thus far is because it's an overreach. They want to make it general intent. You merely did this and therefore liability attaches. So
Mr. I want to hold you there just for a second because we're getting a little bit away from the question that I was asking. But we're going to come back to you. But I want to ask you, Professor Schwartz, in a sense, you're a state employee, right? An employee of the University of California.
Correct.
Right, my alma mater. And you enjoy, and it's probably never come up in your entire career, the covering of qualified immunity in a sense, right, as a state employee.
I suppose so.
Yeah, in a sense it does. So from that perspective, can you think of a benefit of qualified immunity that inures to the public and allows you to do your job? But perhaps we expand that to allow a police officer to do their job.
So I thank you for the question. And I think that there is, you know, when I have spoken to, I think that there is, and my hope is that through this conversation, we could get past some of the sort of rhetoric that I think prevents there from being a place of understanding about what we mean when we talk about qualified immunity and reform of qualified immunity. If we could agree, you know, I can agree that I don't want officers who act in good faith to be bankrupted. And I can also agree with the idea that officers who make good faith mistakes, who are reliant on what they think their policies and their trainings tell them to do, if those people can be insulated from liability as well. You know, and I what I hear Mr. Talbot saying, and what I hear, you know, arguments in defense of qualified immunity putting forth, those are the key kinds of considerations that are there. So if we can put aside the phrase qualified immunity and all of the symbolic power that it is carrying in this current debate and think about, what do we want? We want to make sure that people whose rights have been violated are compensated. We want to make sure that officers who have acted in good faith are not bankrupted. And we want to make sure that officers who have acted in good faith aren't, I mean, I think Mr. Talbot would say as well, are not found to have violated the Constitution because of the other sort of harms that causes. So I think that we could get to those places by ensuring indemnification. As I said, in the state of California, officers are entitled to indemnification so long as they've acted in the course and scope of their employment, which is interpreted in very broad terms. So in California, that indemnification statute, I think, to my mind, does that work. Other states have less certain indemnification, and I am in favor of making other states have the kind of standard that California does regarding indemnification. In my view, as I've said before, I think that the Fourth Amendment already does the work of protecting officers who have acted in good faith and who have acted reasonably and in reliance on their policies. But I would be completely comfortable having an affirmative defense. And I've suggested this to folks in Congress, and I've suggested this to other state legislators, having an affirmative defense where an officer who asserts, you can call it qualified immunity or call it something else, says they should not be held responsible because, and then they have to come forward with, this is the policy that I was relying on that told me that I could make this arrest. Here is the case that I was trained about that said that it was appropriate for me to make this arrest. And if they could come forward with that, then they would be insulated from liability. I'm comfortable with that idea. To my mind, the Fourth Amendment, if you could come forward with the policy or the training, the Fourth Amendment already protects you. But if for the purposes of public debate, we want to have an additional qualified immunity that requires that, that's fine by me. But that's different than what qualified immunity is right now. Qualified immunity is called an affirmative defense right now, but as soon as an officer raises the defense, the burden is on the plaintiff to find a prior court decision, as I said, with virtually identical facts. That's very different than the officer having to come forward and say, here's the policy I was given, here's the training that I was given. And here's one more reason that my proposal, I think, makes some sense. I've looked at hundreds of hours of law enforcement policies and trainings in the state of California. And those cases that supposedly clearly establish the law for qualified immunity purposes, officers aren't trained about them. They aren't trained about the facts and the holdings of these cases that are supposedly necessary to clearly establish the law. Instead, they're taught broad constitutional principles and taught about how to apply those principles in the wide variety of cases that come, or situations that come before them. So officers don't even know about the facts and holdings of these cases that supposedly are necessary to clearly establish the law. So let's get rid of that illusion. And instead, if we want to have an extra protection for officers, some kind of qualified immunity, make it something that the officer must come forward, as an affirmative defense usually is, and prove, this is the policy I was relying on. This is the policy that said it was okay to take $275,000. Or here's the policy that said that I was allowed to release a police dog on this person who wasn't resisting. Or here's the policy or the training that affirmatively said, that gave me belief that what I was doing was appropriate. And if they can find that, then that would be a kind of qualified immunity I could get behind.
Thank you. It's two very interesting approaches from the two of you. I want to get to some of the questions that the community has, but I want to ask just another brief question, and perhaps Mr. Raffin, you can respond to this very briefly, and that is this. You know, qualified immunity has really become sort of a talking point as we have this national discussion over policing and law enforcement, and especially as it relates to communities of color. But there are some folks who are questioning the actions of prosecutors and their ability to have some qualified immunity over their actions and whether they are prosecuting folks whom should not be prosecuted or prosecuting folks in a manner that should not occur. Do you think that this whole notion of qualified immunity, we should also include the judicial system and prosecutors and perhaps even public defenders in this?
Well, that's a very interesting question. My understanding is that judges and prosecutors have something way beyond qualified immunity. They have, I believe, almost absolute immunity, as in you can't sue the judge even if the judge violates the law, and you can't sue the prosecutor even if the prosecutor violates the law. There have been numerous instances where prosecutorial misconduct has led to people being placed on death row, people being imprisoned for long times when they've clearly violated the law that there's no dispute is the law. For example, Brady violations. Brady is a case that says that a prosecutor has to turn over any information in their possession that would tend to show the innocence of the person or even show lessened guilt. And there have been numerous cases where prosecutors have just simply buried that information. I've handled cases like that myself. And even when it's done completely deliberately and with bad intent, you can't sue the prosecutor, you can't sue the prosecutor's office. There are all kinds of reasons why that that rule has been made. I'm not sure any of those reasons hold water, particularly when you have these deliberate and intentional violations, particularly ones that that cause extreme harm to people, false imprisonment for years and decades. So yes, we certainly could reform those rules. You mentioned public defenders. Public defenders can get sued. Public defenders do not have the same level of protections that prosecutors have. So public defenders are lawyers like any other and get sued both the agency and the individual. Should there be accountability for public defenders who cause harm and are negligent? I think just as any profession, just as police who cause harm should not be above the law, as qualified immunity allows them to be to some extent, public defenders and criminal defense lawyers should also have to obey the law.
Anyone else want to give a quick 30-second response to that question? If not,
I would just say I think that yes, judges and prosecutors have absolute immunity, which means they cannot be sued for their individual conduct. And the only thing that could be done is suing the city or jurisdiction for the misconduct of their prosecutors, for example, which is extremely hard to do. I think that all of the justifications for, I don't think that judges or prosecutors would be personally required to satisfy settlements and judgments out of their own pockets in the same way that officers aren't. And I think that there needs to be greater accountability, particularly for prosecutors, than there currently is. There's a true crisis in our system, and it comes from the absolute lack of accountability for prosecutors.
So we're going to go to the public and ask for their comments, but I do want to ask one last question, and I just want a yes or no response to this question, and that is this: do you wholeheartedly believe that changes to the qualified immunity rules will change police conduct on the streets? Professor Schwartz, yes or no?
I mean, I fight the instruction that I can only say yes or no, because I think it's complicated, but I think the answer is yes.
Okay, Mr. Rafflin?
Rafling, it's not a yes or no question. I would say minimally. There's a whole broad spectrum of reforms, particularly reducing the amount of policing altogether, that are important for improved outcomes.
Okay, Mr. Talbot?
I would tend to agree. It's not a yes or no question. Depolicing is certainly, it sounds like an objective of some with regard to that. So if we just don't want cops to do anything, I guess it would have that impact.
All right, Mr. Wheeler?
I would agree. that the defund the police and that narrative and just jumping to conclusions that qualified immunity is the evil when it's not. I would say yes, definitely would impact law enforcement.
Okay, thank you. And I see we have Professor Ocean back, so I'm going to hand the baton back to you, Priscilla.
Thank you very much, Mr. Williams. Okay, so it looks like we have a lot of folks who would like to ask a question. So what we are going to do, I think we have a time limit. So, please, I want to emphasize, we want questions, right? So if you have questions for the panelists, please ask questions. If it is a monologue or an extended comment, I will jump in and I will cut you off. So please make sure that you are asking questions, okay? So let me start. First, I have FC. If FC could be unmuted, so FC can ask their question. FC, you're unmuted. Please go ahead. FC, we can't hear you. We're going to try to unmute you again. Okay, now you are unmuted. Go ahead.
And it looks like there may be a problem with their microphone, so we'll try to connect with them on the back end.
Back to you, FC. I'm going to move on to Nancy Capone. Nancy Capone, please go ahead.
Yes. Can you hear me?
Yes, I can hear you.
Okay. You know what? I didn't have a question. I had a statement, so I'm going to have to pass.
Thank you.
Yeah.
Christian Contreras.
Hey, good morning, everyone. My name is Christian Contreras. I'm a civil rights attorney here in Southern California. I want to ask about Lexipol, these companies which teach these police officers how to respond to statements, and how do you reconcile true, police reform and true accountability when police officers are given an opportunity to review their statements, review the evidence before they give a statement to investigators, which is pretty much the story of the case throughout these civil rights cases. So I know Professor Schwartz has written a law review article about Lexipol's fight against police reform. So I just want to hear the panelists' comments on just the general training against civil rights cases and how to respond to questions after a police shooting.
Thank you very much, Christian Contreras. And Nancy Capone, if you want to come to our commission meeting, you can make a statement or you can write us and indicate your thoughts on this subject. I appreciate you letting us know that you were asking, or you were going to make a comment, not ask a question. And I appreciate Christian Contreras for modeling, asking a question. Question is about officers having an opportunity to review the evidence before making statements, and it's an interaction with qualified immunity. I believe Professor Schwartz was directly mentioned, so I'll start with you, and then if others would like to join, Mr. Rafling, Mr. Talbot, Mr. Wheeler, if you'd like to jump in.
Yes, Mr. Contreras, thank you so much for your comment. And I was going to say, and for those listening, I have two articles, one published and one in draft, about Lexipol, this private company that writes police policies for 95% of California law enforcement agencies. And I'm happy to share it with you, or you can find it. I've tweeted about it. You can find access to those papers if you're interested in learning more. One of the policies that they do recommend is, or one of the policies that they do have, is that officers should be allowed to review all video before they make statements about officer-involved shootings or other incidents. And there is a divergence of opinions. Some agencies that are not Lexipol subscribers follow that, and others don't. And I think that the concern by agencies like the Washington, D.C. Police Department, for example, that does not allow officers to review their videos before making statements, is that officers can change their statements to conform with the video that they have seen, which makes it more difficult to get to the truth. People who are supportive of the ability to watch videos say that officers need the opportunity to refresh their recollection, and to make sure that they recall what happened before being questioned. But the thing that strikes me as troubling about that line of argument is it's not what police investigators do when they're investigating criminal suspects who are not police officers. And so, it strikes me that we should be having the same standards for police investigations, whether those investigations are of officers or of other people charged with crimes. So I think it's very difficult and as a civil rights lawyer, to get to the bottom of what happened in these cases when officers are allowed to review the video beforehand.
Would any of the other panelists like to respond?
Yeah, can I comment on that just for a moment? So, Lexipol is a company that does, I think through its approach, try to establish a uniform set of policies for law enforcement agencies, and agencies voluntarily subscribe to that service. They're not required to do it. And many agencies do in fact have their own policies. And within Lexipol, there are options. No agency is required to adopt the Lexipol recommendations in their entirety and can choose to modify those. We kind of blurred the line here a little bit between statements in a criminal investigation, say an officer-involved shooting incident, which would be investigated first and foremost as a criminal matter, compared to the caller's question about training for civil liability. There's a critical difference between criminal defendants in most cases and cops. Criminal defendants have a Fifth Amendment right not to make a statement at all, as do cops in a criminal case. They don't have to make a statement. Now, for a variety of reasons, depending on the jurisdictions, some do and some don't in criminal cases. And so oftentimes they're making statements for administrative purposes only. The secondary use may in fact be a civil case somewhere down the line, but the answer is not as clear cut as folks might think in terms of the impact. And I've been involved in that debate, and Professor Schwartz enumerated several of the arguments on both sides about that type of thing. But there are other alternatives where people have, some agencies require the statement, then you can look at the video, and then you can supplement something if your memory was not accurate, or refresh your memory in a way that you wanted to clarify something. But you have to understand that video and the recounting of that, or the recording of a video, is just from the perspective of a camera, and it doesn't take into account a whole lot of perception and environmental factors that officers will perceive or not perceive on an incident that may be captured by camera. So it sometimes benefits the entire process by having those officers review that thing, review what happened in the context of making a statement.
Thank you. And unless other panelists would like to respond, I will move down the queue. Next up is actually before we do this, I'd like to turn to one of our wonderful staff for the commission, Ingrid Williams, to make an announcement about how to ask a question in Spanish.
Thank you. Buenos días. Esperamos que hayan encontrado esta conferencia informativa. Aunque no habrá comentarios públicos durante la conferencia, los panelistas van a responder a preguntas del público ahora. Si desea hacer una pregunta a los panelistas y necesita traducción en español, levante la mano o envíe un mensaje vía chat al anfitrión para recibir instrucciones. Gracias.
Thank you, Ingrid. Up next, we have Derek. You're unmuted. Please ask your question.
Hi, yeah, I had sort of a two-part question. The first part is, why don't we require officers to carry some kind of malpractice insurance, much like we do with doctors and other professionals? They are professionals, and in the interest of public safety, they should be held accountable for their actions. And then the second part is, why don't we have sort of a tiered response system? Because I don't think that traffic cops necessarily need to carry guns, but if there's a situation where a gun is needed, then one officer or two officers who are professionals who carry that kind of liability insurance could respond to the call if necessary. And the last part is, I just wanted to say that I don't think that there is a problem with officers being afraid to mess up at their job, because we all are afraid to mess up at our jobs. So I'm not sure that this idea that taking away or changing qualified immunity, making them afraid to do their jobs, is a bad thing, because we're all afraid to make mistakes at our job, regardless of what we do. So, but my questions were mainly around malpractice insurance and why don't we have a tiered response system?
I can take that, Priscilla, if you don't mind. Thank you, Derek, for that question. We do carry false arrest insurance. We are indemnified by the county for, good faith mistakes that maybe have been alleged. And regarding your traffic stop connotation, most of these traffic stops are unknown risks. So we possibly could be pulling over a felon with a gun whose intent is to shoot an officer. So the mere fact that we're pulling over people for traffic violations does not lessen the danger. So the officers definitely need to be armed with both less lethal and lethal force. I hope that answers your question, Derek.
Would anyone else like to respond to Derek's question?
I'd be happy to. I think that officers are indemnified under California law. There are some states that also are thinking about requiring officers to carry individual liability insurance as an alternative or to the indemnification idea. So in Minneapolis, for example, in 2016, there was a city, there was something that was going to get a vote, but ultimately the police union opposed it, and it was struck down. That would have required individual officers to have individual liability insurance with the base premium paid by the jurisdiction, by the city of Minneapolis. But that if their premiums increased because of lawsuits or because of evidence of misconduct, that their premiums could increase and that individual officers would carry the responsibility of those increased premiums. And what that does is, maybe this may be obvious, but it would make, for officers who were a higher liability risk, it would pass some of that risk to the individual officer in the same way that doctors, for example, who are repeatedly sued, have an increased risk, and so that is an idea that different jurisdictions are thinking about and continuing to think about. Regarding the question of having guns or people with guns doing low-level traffic stops, I think that there are a lot of interesting discussions that are going on about how to address low-level traffic stops, although they do certainly carry the possibility of shooting or other violence against officers. The data indicates that those events are extremely rare, although they are the trainings about traffic stops talk a great deal about those risks. They are quite low, but they do still exist. Yet there are other ways that jurisdictions are thinking about reducing the harms that can happen to both the people who are in the cars and to the officers, which is to reduce the number of low-level traffic stops that are happening. There is no reason that a person who has violated the law by going through a red light or by not having a tail light on or having an expired registration sticker, those people could be pulled over to the side, a photograph could be taken of their license, and they could be mailed a ticket in the same way that red light cameras do all the time. And we would make things safer both for officers and for the people who are in those cars. And that idea is being considered. Oakland has created, has changed the way in which they enforce traffic violations and have reduced the number of stops between 2016 and 2018 practically in half. And so I think that we need to be creative here. We need to think about ways not just of ensuring accountability and compensation for people whose rights have been violated, but to reduce harm, to people who are being stopped and to officers, and we can do that by changes in policy at the front end.
Thank you. So we have about 10 minutes left. So I just want to ask everyone to be mindful of one, the questions, and two, if we can keep responses short so that we can get through the rest of the queue. And I'm actually going to take 3 people at a time so we can get all the questions on the table, and then you all can respond to whatever question. So I'm going to start with Genevieve. Genevieve, understand that when I ask you to answer a question, I'm not going to ask the panel to respond right away. I'm going to go to the next person. So Genevieve Chavarel, what is your question?
Can you hear me?
Yes, I can hear you.
Well, I like what you presented today. I think, we should keep the qualified immunity on, because I think if you remove it, police have no security.
Genevieve Chavarel, do you have a question? I'm so sorry. We're just running out of time. Do you have a question?
Okay, never mind. Goodbye.
Okay, I'm going to move on to the next person, Valerie Estrada.
Can you hear me?
Yes, I can hear you.
Hi, I just had a two-part question also. I wanted to know if there's ever been a case where our deputies have been denied qualified immunity. And also, if so, what does that do to, or how is that officer protected by the qualified immunity afterwards, or lack of?
Thank you very much, Valerie. I'm going to move on to the next person, which is Yeti Hernandez.
Yes. Hi, can you
Yes,
hear me?
I can hear you.
Good morning. My question is, do you, to all the panelists, do you think raising the level of education required to be a police officer can make an impact or change in the job or use of force as an officer? Can this be part of reform? I would like to know where the panelists stand in this matter.
Thank you. And the last question I'll take in this batch is from Tupe Astatia.
Hi. I wanted to know is what is the procedure that we have as far as when police are involved with shooting and they have past records for past complaints from families that they've shot in Los Angeles? What's the protocol for them? Like, why are they continuing to work and get a pension when they've had complaints, and why? And I would like to know what is the procedure for that, and is there a group or a third party that they're looking into as far as having to involve when it comes to these types of situations?
Thank you very much. So we have 3 questions from one from Valerie Estrada, Yeti Hernandez, and Tupe Astatia. So the one is, what happens when an officer is denied qualified immunity? How are they protected afterward? Nayeli Hernandez asks, would increasing education standards help with preventing misconduct in the first instance so that qualified immunity wouldn't be as big of an issue? And then lastly, Tupe Astatia asks about access to records of past misconduct. How does that impact questions about liability for misconduct? So all of those are on the table. I can just sort of take whoever would like to respond, and then I'll take our last question from Ms. Hirsch if we have time.
I can give it a shot to start. So as to the first question, if someone was denied qualified immunity, in other words, because the court found that there was a previously clearly established violation of a right, then the case proceeds and continues to be litigated and may even go to trial, and there may be a finding of liability or not, because the trial is where the actual facts are found, whether a jury agrees that there's been a violation. As mentioned earlier, there are dozens of other ways that courts can, let's say, cut down a civil rights case through other legal doctrines or just other ways, denial of discovery, evidentiary rulings. So it doesn't mean that the officer will be held liable, but it does mean that the case continues and there's litigation on that question. The second question about raising education levels, that's a good question. I don't believe that it does necessarily make a difference. I remember, when I was litigating against Los Angeles Police Department in particular, these officers that would come in for depositions after being accused of, really bad misconduct, and they had master's degrees, they had higher education consistently. I did major research into the Tulsa, Oklahoma Police Department because there had been sort of widespread allegations of violence and other misconduct, and they have a requirement that every officer has a college degree. So I don't know that more education is necessarily the answer. As to the third question on past complaints, I think it depends somewhat on the department. Some departments track past complaints better and might use it more than others to limit or discipline officers. On the other hand, and this gets back to one of the previous questions, complaints get investigated by the department itself, and the department has often an incentive to find the complaints to be untrue or unfounded. They have an incentive to essentially give their officers a pass. In the Tulsa report, there was something like over a period of a couple of years, 1,700 incidents of force, and only 2 were found out of policy. No discipline imposed on either of those 2. So the point being that there's somewhat of a conflict of interest when police departments are investigating their own selves. Some may use that to control or limit officers more than others.
Thank you. We have about 3 more minutes. Would anyone else like to respond? Okay, Jane Hirsch, you were going to get the last question. Please make it quick.
Is there a legal definition of bad faith or good faith where we could really find out what was misconduct versus a mistake?
Thank you very much for that question. Would anyone like to respond? Herein lies the problem, Jane Hirsch. I suspect. Does anyone have a definition of good faith versus bad faith?
I mean, I think that you have the pause from us all because it ends up being very context specific, whether the officer knew that what they were doing was wrong. And this is, what the Constitution, the Supreme Court has said that the Fourth Amendment, which protects against unreasonable searches and seizures, recognizes that officers have to make split-second decisions, that we shouldn't judge those decisions with 20/20 hindsight if they're reasonable mistakes. And so that's the way in which the standard has played out as far as constitutional violations go. And so once we put aside qualified immunity, which also, qualified immunity no longer really has anything to do with whether an officer acted in bad faith. It's really about whether there's a prior court decision. But bad faith really only comes into play to the extent that it would show that an officer was acting unreasonably, knowing that they were acting in violation of they were using unreasonable force.
And another complication is that, for example, in the context of, say, racial profiling or racial discrimination, the court actually does not necessarily require an inquiry into the officer's subjective state of mind. It's sort of what would a reasonable officer have thought or done or said or did in a certain situation. So it's a very complicated area, and it's a good question that you ask, and we appreciate you asking it. We also appreciate the panelists sharing their time and expertise with us on this very complicated area of law that has real and often very devastating impacts for communities who are affected by police misconduct and police violence. Obviously, there's also very clear concerns from law enforcement about the role of and the future of qualified immunity in policing. So we appreciate Mr. Talbot and Mr. Wheeler for being here and sharing their perspectives as well. We appreciate all of you for signing on for 2 hours and participating in this conversation. We will, I'm sure, have many more going forward, and the commission will be engaged in this conversation in the future. You can join us at our next commission meeting on Thursday, September 23rd, from 9 a.m. to 1 p.m. to learn more about the work that the commission does. And if you'd like to submit questions or comments that you weren't able to ask here, you can go to our website at coc.lacounty.gov. We look forward to hearing from you. Thank you all again, and have a good rest of your day.
Thank you. Good day.